Money is not neutral. It carries culture, history, and expectations.
Join us for honest conversations about the real costs behind how we live, love, give, and just survive in this complex world.
Money. It is not black or white.
Powered by GoTyme.
Kinna Mapalomaku.
And I'm Maya Fisher-French. Welcome to our podcast.
Now, Maya, in the last episode, we spoke about the exorbitant costs of weddings. But one thing people never ever focus on is the type of contract they're going to get married with.
And, I know you're big on social media about this because it drives you mad that people are spending tens of thousands of rands on the wedding dress, on the flowers, and they months of planning.
Oh, yeah.
But they never think about probably the most important financial document that they will ever sign.
And what do I often hear? When I ask that question, Maya, people say to me, oh, but those contracts are so expensive. And yet, like you said, the cake, the catering, everything costs tens and tens of thousands of rands.
So we've decided that today, we're going to give you some input and understanding as to what your marriage contract means and why you should have one. But because I know that Mapalo is so passionate about this, I've made sure that I have brought in probably one of the leading specialists in this area, family law specialist Beverley Clark of Clark's Attorneys, who has won one of the most important constitutional court cases that relates to marriage regimes. And we're going to discuss that, Bev. We're going to talk a little bit about the Grayling case, but also a more recent constitutional case regarding lobola and customary marriage. So this is an incredibly evolving and exciting area, and you're hearing about it right here on our podcast. So welcome, Bev, and maybe just kick off on the Grayling case.
Sure. Thanks so much. Thanks for having me. Those two cases are enormously important because they fundamentally affect thousands and thousands of people's lives. And we're seeing that already with the Grayling case, and now we're going to see it with the new VVM case. And some people, I think, to their bitter regret, that particular case. So the Grayling case, what that says is if you are married with an antenuptial contract that excludes the accrual, in other words, a complete separation of assets, you now, at the end of the marriage, have a possible claim to a redistribution of assets, notwithstanding the terms of your ANC, in order to avoid unfairness. So if I can use the story of that case, you have somebody, a woman who was married over 30 years before. She was 22 years old. The day before the wedding, the prospective father-in-law places a contract in front of her and says, if you're going to marry my son, you're going to sign this. So she looks at it, says, ANC, no accrual. What's yours is yours. What's mine is mine.
And she's entering with no money.
And so she thinks, well, if I don't, the father-in-law says, if you don't sign it, you're not marrying into my family. And so she signs the contract, as do many, many women. They have very little bargaining power. It's the day before the wedding. All the guests are coming. The dress is bought. The flowers are being put into the wedding venue. And they're in love. And they think it's all going to be fine. And fast forward 30 years, she has stood by her husband's side. She's watched him build an enormous business and an agricultural business. And she has raised 3 children. And she has made contributions which may not be financial in nature, but which are, I'm sure we would all agree, extremely valuable. And they're unpaid contributions, of course. And come the end of the marriage...
he ends the marriage.
It's a long story. The marriage ends for whatever reason. And he says, thanks very much. Sure. It's been real. You can leave. And she came to see us, having been to see about 4 attorneys before. And she said, they all tell me I've got no claim because of my antenuptial contract. And I said, yes, it's correct in law. That is the law. But I'd like to challenge it. And would you be interested in taking it on? And she said, yes, I would, which was a very brave thing because her husband had deeper pockets and he was really determined that she was going to get nothing. And we took it on, went through the High Court and then the Constitutional Court. And the court looked at they looked at gender inequality and the fact that usually an antenuptial contract benefits the wealthier spouse because it means you're not married in community of property. And that very often women don't really have much bargaining power when it comes to entering into the contract. And that we in South Africa look at everything with a constitutional overlay. We look at including contractual sanctity. And we look at the issues of dignity, equality, the things raised in our Bill of Rights. And so we look at everything through that lens. And if there should be some sort of a discretionary remedy in the interests of justice, our law allows for that because of our constitution. And so it doesn't invalidate antenuptial contracts, but it means that if there would be significant inequity, if you got nothing at the end of a marriage, you are entitled to say to the court, please look back at the marriage, look back at my behavior through the marriage, my conduct, the role I played, the support I gave, and see if I am entitled to some sort of redistribution of assets. So it is a discretionary remedy.
And I think there, for me, what it did is it spoke to unpaid labor, which is so much falls on women. It falls on women in terms of child raising, often looking after elderly parents. Many women are looking after their spouses' elderly parents. And I think that is where the point is that we only look at money in terms of the rands and cents that you may earn, not the contribution that you make to a family. So I think this was a very, very interesting ruling. A lot of pushback, though.
Well, interesting, though, because I actually said in the case, and our advocate was like, maybe that's a bit much, but then we did actually include it. I said that the very definition of slavery is work without compensation.
Sure.
And I do think that it might sound dramatic, but I think you're actually correct. It is about unpaid labor, and also how do we value the role that traditionally women and homemakers play. I mean, what could be more foundational, actually, as a cornerstone of society than people who are raising our children or homemaking, and also often working as well. In fact, usually.
Sure. But now, Bev, you signed a contract, right? And you go back and you say, well, this is unfair. How do you make sure that whatever the outcome, so you do say that, okay, we are going to take a look at this. How do you quantify that?
It's the judgment didn't speak to that. And that is what is now slowly coming out in the case law, and that will be developed in the case law. However, it's important to know that this remedy always existed, but it only existed for pre-1984 marriages. So our courts recognized before, well, our legislature recognized before, that because of the particular nature of intimate contracts, marital contracts, there should be a remedy in certain circumstances, an equitable remedy. And it's just that has now been extended to contracts post-1984. So we do have a large volume of case law on these claims, redistribution claims, and it's just that they were for pre-1984 marriages. But the courts have generally looked at around 30 to 40% of the other spouse's estate.
And if, this ruling just happened, but let's say you got divorced maybe 3, 4 years, 5 years ago before, this new ruling came into being, and you've concluded the entire divorce process, can you go back and say, well...
No.
So it's not, it can't go...
Yeah. No, the court was very clear about
forward.
that. Yeah.
Otherwise, they would have
No, can you
tons of
imagine?
people.
Yeah.
Can you imagine everyone constantly flooded? But Bev, I was reading an article where you were being interviewed about this, and you said the amount of women who've contacted you subsequently who feel they can now exit an abusive marriage.
Yeah.
Very interesting.
Yeah. And I think that shows how many women stayed in marriages because they felt financially or economically trapped. And the marriage might have been unhappy or even abusive, but they simply couldn't afford to leave. And now they can. And that shows you how empowering this ruling has been.
Sure, that is so powerful.
Very powerful. But I know the other Constitutional Court case that we really want to talk about, and I know you've actually just come from a seminar on it, so you're really up to scratch, is this one about when are you legally married under customary law? And this is, and I must just mention that Mapla and I have done previous podcasts, and we actually had Lorata Sirocco from your practice talking about this. This was before this constitutional case, and she always said, you know, once those labor negotiations are done, you are married. So maybe just give some clarity, because this court case really gave clarity to that.
Okay. So what the court said is that in South Africa, customary marriages and civil marriages are equal. They're the same. Whether you're married by way of customary marriage or by way of civil marriage, you are married. And those marriages can only be dissolved by death or divorce. Our Matrimonial Property Act is very clear that you cannot change your matrimonial property regime. You can't amend your ANC without the consent of the High Court. Okay? So, but what was happening and has happened with thousands and thousands of couples in South Africa is they would get married by way of customary law. So they would do the lobola negotiations, the handing over, the celebration, and they wouldn't even give thought to having an antenuptial contract. That marriage is then in community of property. That's what the law says. Then at some point, sometimes years later, they would decide, we want to go and have a civil wedding. And so we must go to a lawyer and get an antenuptial contract. And many lawyers were saying, yeah, sure, here's your antenuptial contract. But that's not an antenuptial contract, it's a postnuptial contract because they're already married. And you can't sign a postnuptial contract without the consent of the court. So what our courts have said, what the Constitutional Court judgment says, is if you went and you signed what you thought was an antenuptial contract, but it was after your customary wedding, that is a null and void contract. You are married in community of property. And so that makes an enormous difference to people like, you probably know, Black Coffee, who had exactly this situation and now is married in community of property, having made millions and millions of US dollars, actually, and having thought he was protected by an antenuptial contract, but he isn't.
I'm interested to know when he signed the antenuptial contract, only once he realized that he was going to be building wealth. You see, that's why the High Court has to be involved, because you may suddenly be wanting to introduce a contract because
now you've built a substantial amount of wealth.
Yes.
Well, what this judgment actually focused on was the fact, so this particular couple, they were married in 2011 by way of customary marriage. And they were together, built wealth together, etc., until 2019. And then they went and signed what they thought was an antenuptial contract before their civil wedding. And that then said, well, our commencement values are nil, and we're moving into this marriage, and everything we make during the marriage we'll share. And what the wife said to the court was, well, excuse me, what about what we made during the last 8 years? And what the court was saying was that that's where women are being, usually women, are losing out with these kind of ANCs, which are really postnuptial contracts, is that no regard is being had to what happened to the joint estate. And so it's not that there's no remedy. I mean, so for all the thousands of people out there who find themselves in this situation, they are where they have had a customary marriage, then they signed an ANC, and then they had a civil marriage. and now they're sitting there suddenly having realized, wow, now I'm married in community. They must go and see an attorney, and they must do what's called a Section 21 application to change their matrimonial property regime. So it's not that all is lost. You can still go and change it, but those applications, Section 21 applications, must be made jointly by the spouses. Okay. So
really worth getting an attorney in to make sure you're doing this properly.
But also,
and it's a complex application to the High Court. You have to have.
But I think a lot of people would be asking themselves, how much will this cost us? Or is it dependent on the value of your estate?
Not dependent on the value of your estate, but it's a cumbersome application. It involves notification to creditors. So in South Africa, antenuptial contracts are public documents registered in the deeds office. And the reason for that is that when you go and you buy a car on finance, or you want to buy a new home or whatever, the institution that is giving you finance wants to know who it can claim its money from when it all goes wrong. So they want to know, these people married in community of property, in which case there's a joint estate, we can claim from both of them, we can go and get the family home, whatever, or they're married out of community of property, in which case they can only look to you, the person who signs the contract. So that's why when you're changing that contract, it changes the rights of creditors. And that's why it is like this cumbersome two-stage process where you have to advertise in newspapers and you have to send out registered letters, whatever those are. And you have to show that you have notified all creditors. You have to set out in detail to the court in your affidavit what all your assets and liabilities are, how this is not going to affect creditors now that you're no longer going to be married in community of property. And so any High Court application, especially when it involves affidavits, involves full financial disclosure, it involves the lawyers interrogating, really, have you told me everything? Or what if you own a private company? Then we're going to have to value that private company. We might have to get accountants to value the private company. So, you are looking probably at between 50 and 100,000 Rand for that application.
Sure. But where you could have just signed that antenatal contract right from the get-go.
Yeah. But again, imagine how much you can lose if you don't do it.
Oh, yeah. Yeah. So you have to weigh the pros and cons. But sometimes, especially on social media, right, you've had people say, oh, but we'll just get divorced, then remarry. Is that something that people should be considering? Is it legal? Is it...
No, it's a fraud on the court. You have to tell the court that your marriage has broken down irretrievably and there's no prospect of the reconciliation of the marriage. And again, the theory behind it is that it's a status issue, status as in what is your legal persona? Are you married? Are you divorced? Are you single, etc. And I'm not sure, frankly, the extent to which the state is entitled to know why your marriage has broken down, or that it has broken down. You are entitled to go and say, well, we want to be divorced, I think. But as things stand, the grounds for divorce in our Divorce Act, although it's a no-fault divorce, you do have to prove to the court that the marriage has broken down irretrievably. So I'm not saying many people don't do exactly what you're saying, but they are having to actually tell a lie to the court. And of course, that's perjurious. That's perjury.
But I want to take a step back just quickly where you were mentioning the creditors, because I think that's something, a lot of people wonder why they should have an antenuptial contract. And one of the big ones is creditors, because when you're married in community of property, and a lot of people think, oh, well, the creditors can only come after half of my estate. They can come after. So if your partner goes and runs up a massive credit card bill or debt or gets into huge financial difficulty, they can come after the spouse for 100% of that liability.
So let me tell you a story, Maya. Somebody came to see me last year, a very hardworking man who had built up a business. He was an artisan. He might be a plumber or something, but he'd worked really hard from absolutely nothing to build his business over a lifetime with his wife. And it then came out that his wife had been stealing money, embezzling money from her employer. She was a bookkeeper, I think, in a business. And over a period of years, she had stolen millions. And it was more, what she had stolen was more than his business was worth, his pension, their family home, everything that he'd worked for his entire life. But they were married in community of property.
Sure.
And so the company, the wife went to jail, and the company came to him and said, pay. And he said, but I had nothing to do with it. It was criminal behavior on her part. And they said, sorry, you have the assets and it's a joint estate. So nothing is safe if you're married in community of property. You cannot ring fence anything from creditors. And that's the reason to consider having an antenuptial contract.
Absolutely. Now, I know you, Mapelo, signed, she was so sussed. She signed hers before they even started Labola negotiations.
Well done.
Yeah. So when we finally decided that we were going to get married, in our culture, you have to send the letter. So as soon as the letter was sent, I said, okay, now let us go see a notary and get this thing signed. So we went and signed an antenuptial contract out of commuter property without the accrual system.
Without accrual system. Now, this is so interesting to me because that is not usual for a woman. You chose that.
Yeah. I did. And, I was kind of reflecting on this, Maya, like, why did I choose that? And I think there's some sort of hyper independence that I certainly do have. I'm working on it. I've worked on it. So it was just knowing. And I think also because I studied this thing and I remember hearing it in class and reading about the implications when we're doing case study. And I thought to myself, I'm going to get married out of commuter property without the accrual system the day I get married. But I think what it has done for me, it has made me, again, hyperactive towards my own finances, knowing that I'm putting money towards my retirement annuity, knowing that I'm putting money towards my other investments, and not always, as women often do, give until I have absolutely nothing.
Well, and as we discussed once before, I remember, and there was a woman there who had used all her money for the consumables.
Investing in making the home beautiful whilst he invested.
Yes. And thinking that, that's our money. But should there be a divorce, then you will really feel the pinch.
But it's interesting. So you decided to get married at a time before the Greyling case, and you got married out of community with no accrual. Now, and I think you said just now, maybe it was 10 years ago.
Yes.
We discussed it before we started the program. I think that it shows you, and I get and I respect what you say about the hyper independence, but it shows you the extent to which we are unable at the time that we enter into an intimate contract. It is very hard to project what's going to happen over the next 10, 20, 30 years, 40 years, if you're lucky. And that is why those contracts should be dealt with differently. It's not like, buying a house and we're going to buy it, pay the money, move into the house now. It's a contract that you sign at year A.
And we had zero back then even.
Yeah.
And you have no idea how
you have no idea what's going to
Mm-hmm.
play out, And, let's say, heaven forbid, one partner becomes very wealthy and the other one becomes disabled, for instance. There are all sorts of scenarios. And that's why I think it's really important. I think in all marriages, our courts should have a discretion, even in accrual marriages. And that actually is one of the things in that the review of matrimonial property, which is a huge document and it has many years to go before it's going to actually change any laws. But that's one of the things they look at, actually, and they suggest is that courts should have a discretion, should always have a discretion, as they do in some other countries, particularly in England.
Mapelo, I'm interested on your observation on this, right? So you talk about hyper-independence. And I have to be honest, if I look at my white female friends, there is definitely more of a sense that their husbands will look after them financially, or they don't have to worry about the finances quite as much. They're a lot more disengaged with the finances than my black friends, who seem to be a lot more, they're almost a sense of, I'm on my own, I need to look after myself. Do you think that is a reflection?
I think so, Maya. I mean, we have done a lot of workshops or events, and 90% of the people there will be Black women because they are more engaged. They want to know how they can take care of themselves and take care of their kids. And I think it has something to do with a lot of how people grow up, where, yes, I mean, you've seen the numbers. A lot of women are heading the households. So definitely, I think from us, we are taught at a very young age that you have to be independent. I mean, I had a loving father, very supportive, but even with him, actually, even with him, he taught me to be financially independent. And that was such a big thing that he drilled into us with me and my siblings, and saying that you need to be financially independent. Do not depend on a man, he would say.
Yeah. A man is not a financial plan.
Yep.
And I mean, Bev, you and I did a podcast like 2 years ago where we spoke about, we had a woman on who had just sleepwalk her way through her marriage. I mean, she was an earner, she had a career, but she never looked at all at the financial consequences of her marriage. And that exact thing of spending more money on the home, on the children,
consumables.
And consumables, and not investing in assets. And
of course, it's because you trust your spouse, and you're entitled to. You should. That's the whole point. But unfortunately, we see it from the other end, and that often that trust was unfortunately misplaced, and often one party had a plan and the other one didn't. But I also think from what you've said there, Mapalo, is 60% of South African children grow up in without a father, grow up in a household with a mother. And that is probably also plays into that culture of women knowing, I'd better make a plan, I'd better look after myself because there ain't no man coming to do it for me.
And now, Maya, what contract do you have and why?
So John and I signed an ANC with accrual. We were 22 when we got married. So we were nothing. We didn't have anything to our name. So everything we entered the marriage with was nothing. And we looked at it as building our wealth together. So that is our marital contract. But Bev, when somebody comes to you, and I mean, I do think it's really important to get good advice. Yeah. But what generally do you see as the more favorable contract? Or do you think, it depends completely on the individual?
So I think, firstly, you get proper advice. People think they're going to go and get these cheapies. Oh, somebody's going to do me an ANC for 2,500 rand. Just run a mile, because they're not going to sit down and really talk through with you all the different options and what they mean and what the ramifications are. And they're not going to interrogate your financial disclosure, and you're doing yourself a real disservice. So the accrual system, the idea is that you're going to share, that marriage is a partnership. You're going to share whatever you make during the marriage. But many people abuse the accrual system when entering into their ANCs, and the other partner doesn't realize. So what they do, you're entitled in terms of our law to exclude certain assets from the operation of the accrual. So what people do is they say, I am excluding my business, and that's never going to form part of the accrual. Come the end of the marriage, all that person's wealth is in their business, and they owe the business money, and they structure things such that they never have anything in their name.
Make sure all the investments are done in the business name.
Exactly.
People are devious.
Yeah. So it completely defeats the object of the accrual system. So that's why it's really important that you get proper advice. And in fact, I go one step further, and I insist that people have independent legal advice. Each party has their own legal advice. And one of the reasons for that is that, as you know, South Africans export themselves all over the world. And in many countries in the world, if you didn't have independent legal advice and you didn't make full financial disclosure, your ANC is not worth the paper it's written on. It's not going to be enforced in many other countries. So so fundamentally, I think people should each have their own legal advice at the time of entering into the contract. They should make sure they're getting somebody really talking them through it. And they must go to a specialist. Don't go to, your fiance's cousin who lives in Pofada and says, as a wedding present, I'm going to give you an ANC. You say, okay, thanks. I mean, you can't believe how often that happens, and you can't believe how people...
I mean, as long as the person is a lawyer, it could be...
Yeah, and they don't know. I can tell you there's another kind of very common ANC, and I won't go into it because it's a little bit complicated, but loads and loads of notaries in this country have drafted people's antenuptial contracts with an error. And the Supreme Court of Appeal has held that those contracts are void for vagueness, and those people are married in community of property. That also affects thousands and thousands of people.
Should I be going back to get
their ANCs need to be rectified? Yeah.
Absolutely. No, and again, it comes back to, I suppose it's difficult when you're getting married and it's all love and all the rest to say, well, what happens if? But it's not just on divorce, it's also on death. These really matter as well when one partner passes away. So I think this is, I think the point of this conversation really is to say this is complicated. There is new rulings coming through all the time. Get good advice and in fact, be like Mapolo. Before you even get married, sign the antenuptial. Before you even started choosing the dress, you were doing this.
Bev, and I think, Maya, it's such an important thing that you bring up. I think a lot of us and what people have said, they have said, well, if I go sign this contract and our families do not agree, what does this mean? I've signed some legal document. Does it mean I'm married to this person even though... So I think there's also confusion that, is this thing legal even if we don't pull through with the lobola and the wedding?
No, the ANC is contingent on you actually getting married at some point. So yes, you sign your ANC, but it's meaningless unless you actually get married.
Now that's very worth knowing. So because you're now saying, well, what if halfway through the uncles decide that they're not happy?
Or you decide that, you know what, I actually do not want to be with this person.
Yes.
And I think that's what the fear is sometimes, that I don't want to go signing things and things don't pan out.
Okay.
And that's why you find that people will later go to a notary to get that done once they know, okay, this thing has finally gone through. Exactly.
The problem is now it's no longer
valid. There we go.
It's a just in case thing. Just go and sign it just in case.
Do it, and it just as a backup. But we've spoken a lot about civil marriage, but of course you also have civil union, and I just want to quickly speak about that for same-sex marriages. How does that? Is that very similar situation? You should go see a lawyer. Same rules apply.
Yeah, it's a silly differentiation. Actually, it shouldn't exist. It's like a separate but equal thing. It's and the new Marriage Act will change that. So a civil union is exactly the same as a marriage, a civil marriage, and you also have to go and get an antenuptial contract beforehand if you want one, or you have to bring a Section 21 application if you want to enter into one later.
Okay.
And cohabitation, I mean, there is real life law in South Africa. Then there's TikTok, where people always say,
TikTok.
if we live together for 5 years, what do you have any claim against someone's estate?
So this is a podcast. So there's video. And if you're watching, you've just seen Bev. So for those who are just listening, her eyes are closed and she's shaking her head from side to side to side.
So we don't live in Australia.
Yes.
Okay. That happens in Australia and in very few other countries. But in South Africa, there is no protection for cohabitees. And there are some exceptions, but they are hard to prove. You have to prove that you had what's called a universal partnership, that there was basically a tacit agreement between you. It's a difficult claim to prove, and it's not the way to go. Okay, the way to go as cohabitees is to sign a cohabitation contract if you want to have any claim against each other, or you want to protect your own assets, or just to know where you stand. And it will probably change at some point, but we've been discussing it for years and years and years, as in fact, same as England and Wales. I mean, I think they say they've been discussing cohabitation contracts, their Law Reform Commission, for some 30 or 40 years, and still nothing has happened. It is a very fraught subject, but as a starting point, assume that you have no claim at this stage until there's a test case, and maybe our Constitutional Court will come down on someone's side there. But no, there's no common law marriage.
And I think when we discussed this with Loranta before, she said at least have a will. That's also one way.
Yes.
So if you are living together and you want the other person to have the assets, you can deal with that at least in a will. So that is one way of doing it as well. That's obviously on death.
That's on death. The problem is when people break up and suddenly the person they really loved last year, they really hate this year. And many people are not interested in doing the right thing at that point.
Yeah.
Great. Well, thank you so much. This was so educational for me as well. I mean, such interesting insights and I think so relevant to our listeners because especially with the new cases, the case law that's changing all the time. So please go spend the money on the contract, not just on the wedding dress.
Yeah.
Or the Section 21 application if you find yourself in Black Coffee's position.
Yes, exactly.
And I think also go back to read your contract, right?
Absolutely. We put it in the drawer. We sign it, we put it in the safe or the drawer, and great. I mean, it's great that you do that and hope you never have to look at it again. But really go and look at it. And if there's anything in it that you don't understand, just go and spend the money on seeing an attorney for half an hour.
So now I know what I'm doing for the weekend. I'm going to dust off my continental contract and go through it and see what does it actually say, right?
It's worth looking.
It's definitely worth it. Yeah.
Well, thank you very much. And to our listeners, we would love your feedback. We would love to know how many of you have just suddenly realized that you're married under community of property when you thought you had an ANC.